Can you guys hear me?
Yeah, Captain can hear you. Okay, so well, let's start the webinar first. And today's topic is the safe port, and the moderator for today's webinar is Mr. Jamit Marker. Well, Jamit Marker, a unique combinations of academic prowess and experience in commercial, technical, dispute resolution, and senior management roles defines Jamit's career. With about 40 years of practical and diverse hands-on knowledge base, Jamit conducts learning and developing sections for all levels of shipping professionals, including universities. He is a maritime arbitrator with expertise in charter parties, bills of lading, shipbuilding, and repair. He is the chairman of the Institute of Chartered Shipbrokers, Hong Kong and that of the Maritime and Logistics Committees of the Hong Kong Center of International Commercial Arbitration. Jamit is a member of the WISTA Hong Kong Committee. Yeah, Jamit, please.
Thank you, Manson. Really appreciate. Ladies and gentlemen, welcome to the first webinar of the series between WISTA Hong Kong and Institute of Chartered Shipbrokers Hong Kong. And we are very pleased to have you here with us. What could be better than this? ICS HK and WISTA HK collaborating to organize knowledge sharing events like this. As many of you know, formed in 1974, the Women's International Shipping and Trade Association, which is called WISTA International, is a global organization connecting female executives and the decision makers around the world. WISTA International serves as a connector for its network of more than 3,800 female professionals from all sectors of maritime industry. WISTA Hong Kong was established in 2007. Its members represent all aspects of the Hong Kong maritime cluster, including ship operators, charterers, marine insurers, and law firms. WISTA Hong Kong is very active in organizing, networking, and knowledge sharing events throughout the year. ICS, the Institute of Chartered Shipbrokers, represents all aspects of the shipping business and includes in its membership not only shipbrokers, though we are called chartered shipbrokers, not only shipbrokers, but ship owners, charterers, agents, forwarders, and other shipping professionals. It is dedicated to the setting and maintenance of the highest standards in international transport and shipping business. The Institute's qualification remains the unique hallmark of professionalism in the world of shipping business. Friends, I'm delighted to introduce our panelists to you for today's discussion brought to you by WISTA Hong Kong and ICS Hong Kong. Dimitris Serenakis, whom we call Dim very often. Dimitris is the managing director of Shanghai office of the Ship Owners Claims Bureau, Inc., the New York-based managers of the American Club, P&I Club. He is the club's regional claims director for Asia. Dimitris is dual qualified solicitor in London and Hong Kong and has over 18 years experience as a shipping lawyer, most recently gained in the Shanghai branch of a leading international shipping firm. Dimitris has lived and worked in Hong Kong and China for the last 15 years. Welcome, Dimitris. Catherine Smith. Catherine is the General Counsel and Company Secretary at Vakwong Maritime Transport Holdings Limited. She is a solicitor qualified in England and Wales, Scotland and Hong Kong. She is a fellow of CIARB with substantial experience working on complex shipping matters, both contentious and non-contentious. She is experienced in multiple jurisdictions, including the English and Hong Kong High Courts, LMAA, HKIAC, SIAC, ICC, and CTEC arbitration forums. Catherine is also the past president of WISTA in Hong Kong. Thank you for joining us today, Catherine. Captain Rajiv Tetarbe, a fellow of ICS and Nautical Institute. Captain Tetarbe is a shipping professional with over 2 decades of experience in freight operations, shipping management, sale and purchase of ships, and marine insurance. Presently, he is associated with Chelaram Shipping Hong Kong Limited as its commercial director. He started his short career as a dry cargo broker in Dubai and thereafter moved to commercial operations connected with container shipping in a feeder segment. Soon thereafter, he joined the dry bulk segment in owner's office, where he was in charge of chartering and operations of bulk carriers. He is well-known name in the dry bulk shipping fraternity in Pacific. Good to have you with us, Captain Tetarbe. Well, today's webinar is planned basis English law, and as we know that case law is always evolving. So let me begin with asking them, what is the law relating to unsafe ports? And then possibly Catherine can further elaborate on the changes which have happened over the years. Dimitris, please. Dim, you are muted. Dim, can you unmute yourself, please?
I can now. Thank you for that introduction, Jagmeet, and apologies everyone for the slight delay. A very warm welcome from me too, and I hope you find this session informative. There is a lot to unpack with unsafe ports, so I will try to be as succinct as possible while I provide this historical overview, and then I will pass the floor, as Jagmeet mentioned, to Catherine, who will hopefully provide an update of the most recent developments with regard to unsafe ports. The law surrounding unsafe ports is a very important contractual provision which appears in virtually all time and voyage charter parties. In essence, it's a warranty that the vessel may be sent only to safe ports and berths. The classic test was laid out a long, long time ago in a case called the Eastern City, almost 70 years ago. And it states that a port will not be safe unless, at the relevant period of time, a particular ship can reach it, use it, return from it, without, in the absence of some abnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. And that is the test that has stood the test of time, really. Now, there are several requirements that flow from that definition for a port to be considered safe. One is that there must be safe access to the port, and that means obstructions, usually permanent. So, for example, something like a neap tide, which is a temporary obstruction, will not count unless the delay is inordinate. It must be a port where the particular vessel, particular type of vessel, can lie safely afloat at all stages of tide. There must be adequate facilities for the trade that is proposed and the cargo that's being carried. It must be a politically safe port, free from any war or embargo, for example. And finally, after the ship has arrived and discharged the cargo, she must also be able to leave safely. Now, the port does not need to be safe at the time the nomination is made by the charterers, but it must be safe when the ship is due to reach, stay, and leave it. If the charterers order the vessel to an unsafe port or berth, then they will usually be in breach of contract. If they are in breach of contract, the master has a right to refuse to enter or stay at that port. Now, what happens is occasionally the ship arrives at a port and the port becomes unsafe after the port is nominated. If that happens, the charterers must order the ship to leave if the danger that is presented at that port can still be avoided. That's the position under time charters. Under voyage charters, the charterer doesn't have a right or obligation to nominate a new port. And in that case, the parties have to agree between themselves to vary the charter to provide for a new port to replace the unsafe one. Now, an issue that often arises for owners is how they react to charterers' orders. There is often a fear that they have to obey the charterer's orders immediately, and that is not true. The master's obligation on receipt of an order is to conduct himself reasonably, which means that he's permitted a delay, a reasonable delay, to consider whether an order is worth obeying or not. And this is a fact-sensitive issue, and everything that surrounds unsafe port warranties, as we will examine throughout the course of this webinar, is fact-sensitive. Now, it is also important to note here that if you accept an order to proceed to an unsafe port, an owner doesn't necessarily forego the right to compensation for the breach of the safe port warranty. And what's going to be important here are the communications between the parties, and those will be subject to close scrutiny by people like Jagmit and Manson if it goes to arbitration. So it's important for owners to expressly reserve any right to claim damages, even if they accept to go to a court. The next issue to examine is that it's irrelevant if the charterer did not know and had no way of knowing that the port was unsafe at the relevant time, if there is an absolute safe port obligation in the charter. The position is different if the obligation is one of due diligence, and this is what we often call the contradiction between absolute and qualified warranties. If the charterer is given absolute warranty, then the port must be good and safe. If there is a due diligence only obligation under the charter party, it merely requires the charterer to display reasonable care, and this duty is discharged if a reasonably careful charterer would, on the facts known to them at the time, had concluded that the port was prospectively safe. The next issue that always comes up with safe port warranties is whether these are express or implied. If a charter party specifically names the loading port or berth and contains no warranty as to safety, then no warranty will be implied. The owner is treated as having assumed responsibility for ascertaining themselves whether the vessel can safely approach, use, and leave that berth. If we're dealing with a range of named loading or discharging ports, then the current state of the law suggests that the position would be the same. However, there is authority that the charterers are obliged to nominate only those ports, which it would be possible for the vessel to reach. Generally speaking, the more liberty a charterer has under the charter party, the greater the likelihood of a safe port warranty being implied into the charter. A further issue to consider is ports versus berths. A safe berth must be safe in the same respect as a safe port. But while a safe port obligation will imply a safe berth warranty, the opposite is not the case. If there is no safe port obligation, the safe berth warranty will only apply to movement within the port and will not extend to the approach to the port, which in some ports can extend for tens and tens of miles. Now, there is an issue which I didn't touch upon, and that is the issue of the abnormal occurrence. And that's where my friend and former colleague, Catherine, will illuminate you, in particularly as it relates to the case of the Ocean Victory. Thank you from me for now.
Thank you, Dim. Catherine?
Thank you very much, Dim. That's a perfect segue on to discuss really the case of the Ocean Victory, the details of which may be familiar to a number of you on this panel. And it's a really good case to use to describe some of the issues and the themes that Dim has raised in his really succinct sort of overview of the law of safe ports. And by way of a really brief background, this case involved the vessel the Ocean Victory, which was at Kashima Port in Japan. And the vessel was subject to two rare conditions, or a combination of factors. That was swell generated from long waves, as they were described in the cases, which are common in the North Pacific. And two, a very severe northerly gale force wind happening at the time that the vessel was in Kashima Port. The swells made it potentially unsafe for the vessel to remain in the port, in the berth, and the gale force winds made the Kashima Port fairway, which was the only way in and out of the port, unsafe to navigate safely. One of the crucial issues was that this is something that had only happened, or that this series of circumstances or conditions of the sea in the port, at the port, were conditions that had only really happened together in the port's 35-year history once. There was a decision from the English High Court as to whether or not the port in these sets of conditions was safe under the time charter contract. There was a time charter contract that included an express warranty as to safety, and actually the charter party chain, including the sub-charters, included the same express warranty as to safety. So as Tim has described, the charters had an obligation to nominate a safe port, and the question was then whether or not this was a safe port in these conditions or not, or, as Dim has described, whether or not, in fact, the set of circumstances was an abnormal occurrence. And at first instance, in the English High Court, Mr. Justice Tier fully appreciated how unusual and irregular this set of sea conditions was, but held that they were foreseeable and did relate to the condition or the nature of the port itself, and therefore, did not relate to the condition and therefore was an abnormal occurrence. That decision was overturned by the Court of Appeal, the English High Court. The English Court of Appeal held that, in fact, this set of circumstances was an abnormal occurrence. And the factors that they took into account were the fact that this had only happened once in 35 years, and that the fact that the northerly gale had come up so quickly was really rare and unusual as well. And so it was an abnormal occurrence, and as such, fell outside of the classic definition that Dim has given in the Eastern City of whether or not the port was safe or not. And that decision and that conclusion was maintained by the Supreme Court as well. So the Court of Appeal's decision on that was upheld by the Supreme Court. And the Supreme Court held that the correct approach to take for the purposes of evaluating the prospective safety of the port was to look at whether or not it was a normal attribute of the port or an abnormal occurrence. And you had to take abnormal occurrence not as some kind of legal phrase, but in its normal meaning of the words. Such an approach inevitably includes considering the past history of the port, as was done in this case, whether an event like that had happened before and was likely to happen potentially again. In this case, no vessel had experienced these conditions before, and the severity of the storm that built up rapidly was also taken into account. And in assessing then whether or not the Kashima port in that circumstance was an unsafe port or not, or whether or not these circumstances were an abnormal occurrence, the Supreme Court followed the Court of Appeal and held that it was an abnormal occurrence. What's really interesting, I guess, about Ocean Victory is that it's really a discussion of the interplay between the nature and of the port itself, and also whether or not these are events that occur unusually abnormal occurrences outside of the normal situation of the port itself. And so it provides a really useful guidance on how we apply the Eastern City test.
Right. Thanks. Thank you. Each of you can tell us what could have been the implications.
Jagmeet, I will go first. I think, to be honest with you, I don't necessarily think that the broader implications on this particular issue or the Ocean Victory are as far reaching as people make them out to be. The key, and there were multiple decisions that were made by the Supreme Court, but the key issue here is that the Supreme Court decided that the error was in not compounding together the two abnormal occurrences, but treating them separately. So I think it creates a very specific set of circumstances for the examination of unsafe ports in general. And that's where the decision turned on that particular case. It was the weather and the wave pattern combined together, two abnormal effects taken in as a pair that created the abnormal circumstance. So I think it was a particularly expensive case for the hull underwriters, but I think it has to be seen within the confines of itself to some degree. I think the broader implications are that you really need to examine carefully the history and the variety of abnormal occurrences and not discount a combination of one or more of those together, or two of those, or more of those together.
Thank you. Thanks, Tim. Anything from Catherine or Captain Tetarbe on this?
I suppose
Practically, yeah.
if we, it's academic, but if Mr. Justice Tier's decision had been upheld, it included an element of sort of foreseeability, that it was foreseeable that there would be this long waves from the swells in that region, and that at that time of year storms were known to occur. So would that leave both owners and charterers in a position of having to assess a huge range of potential occurrences that are now kind of brought into being part of the characteristics of the port itself? I mean, I just think the law around this is really about the allocation of risk. And so I think if you added this element of foreseeability in there, it would really expand or the allocation of risk as between owners and charterers, which would be quite difficult to adjust to.
Yeah, thanks, Catherine. Captain Tetarbe, would you ever accept a clause that includes a qualified warranty with regards to the safe port? Charterers might come and tell you that they are satisfied based on the known facts, the port is prospectively safe. I mean, what sort of guidance would you give to your chartering managers, especially when the market is so bad like Q1 2016, and the charterer is insisting, and he's got choices, he's insisting that such a clause has to be included, where it's a qualified safe port warranty and not an absolute one?
My own experience, can you guys hear me?
Yep, loud and clear,
okay.
Sir.
My own experience has been, Jagmeet, that generally the qualifying of the safe port warrant is more witnessed in the liquid cargo trade than dry cargo. I can tell you that last so many years of chartering experience that I have, there is very seldom have I seen in a dry cargo charter asking to qualify warranty. I think it is really expected that's that. But then having said that, possibilities exist. It could come to me, charter that I can. Options, sign and get. I could try risk. In any case, my understanding is that the contract, and primarily the safe port, in my opinion, is always a matter of law and fact, and well known to the industry. There is an apportioning of both the owners are taking. So the situation.
Captain Tetarbe, we are losing you in between. Rajiv, we cannot hear you. You're losing you in between. So I think I'll just proceed with the next one.
Can you hear me?
Yeah, can you please try again? You are talking about apportioning the risk.
Yeah, I was saying, can you hear me now?
Yeah, can hear you now. No, we lost you again.
I was
Catherine,
saying,
yeah. Catherine, what are the possible defenses for a charter to the safe port claims?
Thanks, Jagmeet. So we've spoken a lot already about abnormal occurrences and whether an argument can be made that a particular condition or unsafe circumstance is one which is an abnormal occurrence under the classic definition, or whether or not, in fact, it's part of the characteristics of the port. So charterers would often argue or seek to argue that, as they did in Ocean Victory, that the particular event that may have caused damage to the vessel was something which was an abnormal occurrence and so falls outside of the definition of the safe port warranty, or whether in fact it's part of the characteristics of the port and falls within. And we've spoken about that already in a bit of detail. In the context of COVID, this is really interesting. For example, if owners argued that the port is unsafe due to a COVID infection, we'll talk about that in a bit more detail shortly, then charterers are likely to argue that this is an abnormal occurrence because it doesn't relate to the characteristic of the port itself, but is something unusual and abnormal. However, let's see how this plays out and whether the longer a particular infection goes on in a particular port, whether charterers can continue to successfully argue that if the condition in the port actually becomes a part of the nature and characteristic of the port itself. The other things charterers can do are to defend such claims to say that the danger or the unsafety could be avoidable by good navigation and seamanship. Again, going back to the classic test. And the standard of good navigation and seamanship is that of an ordinary, prudent, and skillful master. So, if the standard required to avoid the risk of danger is actually higher than that of an ordinary, prudent, skillful master, then, following on logically from that definition, the port would be unsafe. So those are your first two potential defences as a charterer. The third then is negligence on the part of master and crew, and certainly being an in-house lawyer acting for a ship owner, and in general, this is not necessarily a particularly attractive line of argument, but it exists. So if a charterer can show that the master and crew was the effective cause of the damage, then the charterers will not be liable for that damage. This is because the chain of causation of following the charterer's orders to that place and the damage caused by that has been broken by the intervening event of the alleged negligence. Again, courts and tribunals will balance the fact, this is an interesting one, between the interplay between the act of master and crew and following the order. Courts and tribunals will balance the fact that the master may have been put in a difficult position and that it was the charterer's order, and so the breach which put the master in that difficult position so that the unsafety influenced the negligence rather than the negligence arising in the first place, so that the two things are sort of interconnected. And see the case of the stork and the polyglory on that. Even if negligence can be served to break the chain of causation, the thing to remember and to highlight here is that the evidential burden of showing that negligence and that negligence broke the chain of causation is very, very high. So it'll be difficult, one would say, and I would say, acting on behalf of an owner, it'd be very difficult evidentially for charterers to successfully argue on crew negligence, breaking the chain of
Thank you so much. then what do you think? Do the arbitrators and the court, do they easily agree with regards to negligence of the master? Or this is something very difficult?
In my
as
experience,
Catherine,
in my experience, no. I think generally tribunals and courts have a lot of sympathy for masters and the crews on board ships that find themselves in difficult positions. That doesn't mean, of course, that they disregard the applicable tests for good seamanship and navigation, or they disregard what negligence constitutes. But I think that they do appreciate that the people on board the ship are under immense pressure to perform, and provided they operate within acceptable parameters, we cannot go around blaming them if an incident occurs. So I think, and what we advise generally is that the sympathy will likely lie with the master and his crew.
right. Thank you for that. So, and also them coming from the P&I club. So, people always look towards a lot of advice. It's an amazing sort of guidance material which is available on most of the charter party disputes and other safety issues. So what sort of insurances would you tell us are available for owners and charterers in this respect?
Sure. I mean, the answer is really twofold. One is what insurances are available, and the other is what insurers can do. If I take the second question first, I think both Catherine and I have emphasized that examining an unsafe port claim is an extremely fact-sensitive situation. And that means that the collection of contemporaneous evidence becomes critical. It becomes of crucial importance in order to protect the interests of whichever party we are helping out. Now, this is the bread and butter of P&I clubs, right? Coordinating between and cooperating with various parties is what we do day in, day out, not just our P&I club, every P&I club. So we have extensive experience and expertise in doing this, and we're really best placed to pull all these strings together and collect the evidence for owners or charterers. But we are not the only insurers that or who are involved in an unsafe port claim. If there is physical damage to the ship, as was, of course, with the Ocean Victory, it's the hull and machinery insurers that will be leading the investigation, and a subrogate insurance will probably have taken over from the vessel owners. And normally, any physical damage caused to the ship would be covered by ship owner's hull and machinery insurance in the case of an unsafe port. That exclude incidents, of course, that may fall under a war risk policy, such as mines and torpedoes and stuff like that. But generally speaking, it'll be the hull and machinery underwriters who are leading in such a situation. The P&I club will have a crucial role if there is a pollution because of the blue cards that we issue. And of course, almost always when an incident occurs like this, there's cargo on board the ship being loaded or discharged or en route. And standard cargo insurance terms provide cover for some of the likely claims that these risks throw up. So they will be involved on behalf of cargo interests. Charterers have, on the P&I side, fairly similar protection to what owners have vis-a-vis their sub-charterers. And as regards their liability to the owners, they have damage to hull policies in place. So that would mean that their P&I club is then defending any claim for damage to hull by the vessel owners. I think that covers your question.
Thank you so much, Dem, for that. It's
You're welcome.
very, very well answered. There are a number of questions which are coming in the chat box. My request would be that please put your questions in the Q&A, and we promise to get back to you by email if we are not able to answer during the course of the webinar. So something we discussed, I think Catherine touched upon COVID-19, and I think that's a quite an important issue. So before I ask Catherine to elaborate more, let me try to get back to Captain Titarbe. If he can explain maybe in 2-3 minutes to bring everybody up to date, because he's the one who is, dealing with the seafarers and the issues that owners are facing. So, in terms of the safety of the port, Catherine mentioned about the risk of infection to the crew, as well as, ships getting detained. So what are the practical issues and experiences that you have faced? Captain Titarbe?
The most important thing is that, can you hear me?
Yeah, not very clearly, but
Can you hear
we'll
me?
try. Yeah, now we can.
I was saying is that the difficulty that we are facing is that do crew changes because of charters required. Charters are not permitting crew change under their charter. So they just simply say, well, not in my charter. Do whatever you want to do next charter, do one before. That is the main practical problem that we are facing right now. But one of the thing that what we are trying to do is that to get all our crew vaccinated. And on the basis of that, we will be fully vaccinated. Some chart agreeing that, okay, crew is fully, we may accept. Though we are still not overcoming the problem of number of days required between the last port to the next port as a charter where he wants to load. Like currently, we have a very big issue between India and China because they are requiring 28 days from the last port. Like Australia had put at 1.14 days. So those issues are still, but one good thing is that as you've heard, the IMO circulars, that people are getting vaccinated. The seafarers are being treated as a part of the essential worker structure. And in addition to what the doing, even the are coming out solutions of master, for example, started a vaccination seafarers. In US, we have just a situation where the agent approve without any cost. So yes, I guess practical, but the only way out nation, there's nothing else you can do. And of course, the testing is available almost everywhere.
Right. I think these are the major issues. So now what we are going to do in the next 15-20 minutes is to bring together, you see, the principles of 1958. Eastern City was 1 year before I was born. So 1958, and then characteristic of the port and the abnormal circumstances, bring all that together with the issues that Captain Titarbe has mentioned, that there are serious ones over there. So how do these things go together? So you can answer maybe some of these questions that the industry is asking. So Catherine, assuming that there is a charter party with absolute safe port warranty, all right, and it does exist in the charter party. So can we say ordering a ship to a COVID-19 infected port might constitute a breach of the charter's safe port warranty, an absolute one in this case?
Yes. If we start from a starting point that there is an express warranty in our time charter party, I think the answer is, and I'm sorry, it's a very lawyery one. Yes, maybe. So if we start from what is the risk? Does the safety have to be one of physical safety? The answer is no. It could be a port could be unsafe as a result of a physical risk or a risk to the vessel's crew's health, and that would be create an unsafety of the port. So the question that raises is then, and this is something we haven't touched on massively about characteristics of ports, is around the systems that operate within ports go into characteristics of ports. But there's a suggestion that the presence of a contagious disease in a port would raise a question as to whether the precautions can and have been put in place in that port and can be relied upon to protect crew from the threat of such a contagion. So if any protections put in place are not enough, it then follows that maybe the port is unsafe. There's some guidance that says both owners and charterers can check whether or not the particular port is complying with international recommendations as to reducing the risk of spread of disease from shore to ship. And if they are, whether that then gives both owners and charterers some comfort and satisfaction that the port from that perspective is safe. Alternatively, if the port fails to meet those standards, owners would have arguably a good argument that the port is in fact unsafe in that context.
Right. Yeah.
The other potential unsafety of a port in this context is that the vessel could be blacklisted from going somewhere else or quarantined from going to a next port. However, there's a question about timing here, and a quarantine period at the second port may not be long enough to render the first port an unsafe port. If we use the horrible Ebola outbreak in 2014-15 as an analogy, 3-week quarantines were sort of thought to be not enough to render the first port an unsafe port. And that's kind of what we're seeing here at the moment in operations, where quarantines are around 2 to 3 weeks, which is an operator, and Captain Tatabi, I'm sure, will say, agree, is actually a really long time from the purposes of determining whether the first port is an unsafe port. The wisdom at the moment is that isn't sufficient.
Right. Yeah.
So in other words, it's going to be difficult to establish either one of these things. But on the first point, I would add that the information on the ground is only going to be as good as the data that's available there. So we certainly would be looking to be relying on the likes of Dimitri and correspondence and local, state and national level health organisations providing good data on the ground to help all of us determine these things and try and avoid having an unsafe port dispute in arbitration.
Thank you. Thanks, Catherine. Thanks so much. Dimitris, if I come to you on this one, earlier while answering, Catherine had mentioned the abnormal situation could have been there moving from 2019 December to January, but as this thing is getting prolonged, possibly it's more to do with that you have been aware of it and some actions are being taken. So from your personal as well as club's perspective, what sort of advice would you have for the owners in this respect?
Yeah, it's a very difficult one. I think the chances of arguing an unsafe port were much higher in the beginning of the outbreak. Right now, they are much more limited, if I would say almost non-existent. I think because the threshold just generally, not just for COVID, of satisfying the unsafe port test is so high, you would require quite a collection of circumstances all happening together, and very strong and clear evidence of these circumstances applying in order to be able to prove now that you are in an unsafe port situation. The delay, unfortunately, the quarantine is an issue because the test requires an inordinate delay, and 2 to 3 weeks, depending on the duration of most charters, doesn't necessarily make it an inordinate delay. So that's one problem. The other problem we now have is, of course, that a lot of the ports have preventive measures, and ordinarily you would rely on the lack or insufficiency of preventive measures for a port to argue that the port is unsafe. What we now faced is with quite the opposite. Ports are being far too robust for our liking, in the sense that they're being far too stringent in the preventative measures that they're applying. So I think that makes it very hard to prove an unsafe port now. I think right now you would need strong and clear evidence of an outbreak that is uncontrolled at a particular port. You need to show that there is limited or none at all preventative measures being taken place by the local port authorities. You need to show some sort of closure of the port as a result of the outbreak. And even that, I'm not sure whether it's enough to carry you over the barrier and not cause owners to proceed to a nominated port as instructed. I think at this stage, the best owners and charterers can do is speak to their clubs and their correspondents and their in-house or external legal advisors before concluding charters. And if they are talking about ports or range of ports or a series of nominated ports where there are known to be problems, that robust clauses are drafted to protect that respective party in dealing with the consequences of a long wait period, for example, or something like that. I think that's the best we can do at this stage.
Right. Thank you, Dim. Captain Tetarbe, now earlier I asked you about the Q1 2016, but now we are in a very beautiful dry bulk market where you are, in the driver's seat. So what Dim has suggested, so are you in a
long live the market?
Long live the market, of course. Brokers also have fun in good markets. So coming to this issue, that are you able to make changes in the charter party clauses similar to what Dim has suggested in terms of protecting your part? What do you think?
That we owners are doing before start any negotiation, we are asking their opinion, the crew change thing we are doing. It's very unusual time chartering people do is this, our clause.
Captain Tetarbe, it's such a pity that,
the presence of the last change, before it was changed. Can live with this before we talk about development that has taken place. What to do with my crew live, the changes, and this is what I need going for 3 months. Can you live with it? Then we negotiate. And there are times when we are frustrated, charterers who not.
Captain Tetarbe, I'm so sorry. We are missing so much of practical wisdom. We are not able to hear you clearly. So we'll just move on to the next part. I'm going to give, we are coming closer to the end of the webinar as far as the panelists, their own discussion is concerned. Now we'll move on to the questions and answers. So before I do that, just one minute, if Catherine, 1 minute, would you like to, what would be the key takeaways for the audience today, and then Dim, and then we'll try again with Captain Tetarbe. Starting with clarity in the clauses, of course, the charterers or the chartering guys should not be leaving these clauses towards the middle of the night, not midnight clauses, but right in the beginning. Other than that, anything else you suggest?
I think, as Dim has said, and it's not necessarily entirely helpful to every operator, but the facts on the ground are really critical. At the time charterers are making a nomination, At the time, owners who have a reasonable time to consider that nomination and accept it or not, or ask for another nomination, at the time they are doing that, and also in the intervening period leading up to the vessel coming to the berth or the port. So for me, it's about good, really accurate facts on the ground at those critical times that make all the difference, trying to avoid a dispute at a later stage.
Right. Then?
Thank you, Jagmeet. I think I would summarize the advice in 2 words, which is due diligence. And I don't mean due diligence in the legal sense, in the sense of do your due diligence before you enter a charter party. I mean, these days, both owners and charterers carry out due diligence on their counterparties to ensure that they're able to pay or run a ship, to ensure that the vessel is not going to run into trouble, to ensure that bunkers are not going to be arrested because some money is owed somewhere. So we do this routinely for our members, whether they're owners or charterers. It's not a stretch to go from that and carry out due diligence on the trade that is proposed itself. And it takes very little time to do that. While you guys take time negotiating freight rates and hire rates, your clubs and their correspondents and your legal advisors can very quickly ascertain what the risks are for any proposed trade. And that's what you, whether you're owners or charterers, should be looking to do. And we're seeing it with our members already, but I wish more people would do it. Very simple. My ship, my charterer wants my ship to call this port to load and this port to discharge. What should I be aware of? And we can have an answer for you very quickly that will allow you to make an educated decision, make a calculated risk on whether you want to take this trade on or not.
Yeah, that's fantastic. Then thank you so much. And also, I think working very closely with the port agents, with the operations in the same office, it's some sort of cross breaking the silos and cross-functional approach could be very, very useful and helpful. Captain Tetarve, would you like to add something?
No, I mean, currently we always were using a booklet that BIMCO used to publish, check before fix. So that fixing is and more now, particularly in this COVID scenario. Your first port of call, they can give you whatever information is required for that port. But even the industry gives you feedback. You know, you can call people, ask them, you haven't called a port, if there is anything different, is anything changing, is there a way around it, and all kinds of things. There are practices available to people. You need to go looking. Dim said, before you get into the charter contract, you better do this practical due diligence, and that will always give you better dividends, I guess.
So that's absolutely fantastic. Thank you very much, all three of you. So now I just want to say about WISTA and ICS. You see how and why we went on to having these webinars. I'm on the committee of WISTA Hong Kong and also member of WISTA International. So I sometimes do request when we get emails, we write dear all and not dear ladies. Anyway, that's on the lighter sense. So what we decided is that we will try and have a drive towards inclusion, diversity. So while we were talking about that, a thought came, let's hear from Benjamin. What is it that our beautiful Hong Kong doing about it in terms of what initiatives Hong Kong is taking on EDI, equality, diversity and inclusion. So Benjamin.
Thank you, Jagmeet, and all the panelists, and also Manson. It's fantastic to be here today, and apologies for the hiccup earlier. Of course, we've got a panel which had a very a discussion which is full of substance, insight, and of course a lot of expertise in it. But I think doing my remark after the panel actually is equally good, because the remark is actually on the diversity, inclusion. And as Jack mentioned earlier, actually it's great to have WISTA on board also as the co-organizer, because I think this is something that we need to look at, and we need to commit very seriously. Now, many ethnic minorities have been in Hong Kong for generations and have played important roles in shaping Hong Kong's history. They have traditionally settled into the Hong Kong family very well, and are very much part of the community. Now, talking a bit of history, for example, the Nepalese has served Hong Kong for over 50 years as the army force during colonial times. And also for those who studied in Hong Kong U, you probably would know also Modi, a distinguished Parsi businessman and a renowned philanthropist, made a major donation toward the funding of the Hong Kong University. So this is a lot of the minority in Hong Kong's roots. For the population of the ethnic minorities, actually has increased by over 70%, 70, over the past decade. Now, Hong Kong is home to some 260,000 ethnic minority residents, accounting for nearly 4% of the whole population. The government seeks to provide ethnic minorities with equal opportunities and also facilitate their integration into the community. This requires, of course, concerted efforts by different government bureaus and also departments. So that's why we have established the Steering Committee on Ethnic Minority Affairs in 2018, which is chaired by our Chief Secretary. $500 million has been earmarked to strengthen support for them. We are also working to improve the administrative guidelines on promotion of racial equality for all government bureaus and departments, as well as organizations that provide services to ethnic minorities. In the past 3 years, we have implemented over 30 measures to support them, covering areas of education, employment, social welfare, healthcare, social inclusion, all that. Among these measures, the amended Race Discrimination Ordinance, which enhanced the protection for ethnic minorities, also came into effect in June 2020. In addition, outreaching teams have been set up by the Social Welfare Department to proactively reaching out welfare needs. In terms of employment, of course, we strive to ensure that people from different ethnic backgrounds and groups enjoy equal access to job opportunities as others, both in the public and private sectors. For example, in our department, Invest Hong Kong, we are committed to promote equal opportunities, and we have actually started recruiting ethnic minorities in our Hong Kong office some years ago already. This summer, we are offering training opportunities to 15 intern students, with 2 of them are of ethnic minorities. Now, going back to the maritime industry, shipping industry is historically a male-dominated industry, yet we are striving to shake up the landscape by promoting diversity in the workplace. 2 years ago, we held the first woman in Hong Kong to qualify as a chief engineer of seagoing vessel. If you remember, there was a ceremony being done in the Hong Kong Maritime Museum. Nowadays, many female officers can be found working in various grades in marine departments. And the department now has about 100 female officers, accounting for about 10% of the total workforce. Now, ladies and gentlemen, building a harmonious and inclusive society demands surpassing commitment and exceptional dedication. Last week, there was a very tragic truck attack that happened in Canada, taking away lives of a family. Again, this would remind us of the importance of inclusion. So please join us to make Hong Kong a better place and create an inclusive and flourishing Hong Kong. Thank you.
Thank you very much. Thank you so much, Ben. I think very well said. I really appreciate that. So now we come back to the safe port. And there are a few questions. I'm just going to pick 1 or 2 out of them. Jeffrey Blum, can we compare a pandemic amongst humans to be political or physical lack of safety in a port or at a berth? Dimitri, would you like to take this?
I don't know is the short answer. I mean, we know political unsafety qualifies as unsafety under the unsafe port or the safe port warranty, but a pandemic such as this hasn't been tested yet. Theoretically, as we discussed earlier, yes, it can be, but factually, I'm not aware of any case. Perhaps you and Manson may know better than me. I'm not aware of any case where that's been put to the test for an incident that occurred at the beginning of the pandemic. I think now it would be too late to bring something on like that. But if you look at it theoretically, legally speaking, yes, there is scope for the pandemic to fall under a breach of a safe port warranty, the same way that political unsafety can. But at the moment, I don't think that all the conditions are satisfied for that to happen.
Thank you for that. And let me see. I've got an anonymous attendee. Is safe port requirement preventing ports from allowing a vessel with a corpse to berth in the port? I think this is the Italian ship. Maybe he's referring to that vessel where the master died, and ship was not allowed to call any of the Asian ports, and the vessel had to be, after declaring force majeure, had to be taken to Italy. Possibly, is a safe port requirement preventing ports from allowing a vessel with a corpse to berth in the port? Could this be one of the reasons for that? I don't think so.
No, I don't think so, because then that's looking at the safe port warranty from the flip side, which is that the port is trying to be safe, but that doesn't come into, it doesn't become a factor when you examine it under a charter party. As a matter of fact, as we discussed, it's the opposite. You can't call a port unsafe because it's being extra safe, even if, especially in circumstances that you don't like it. I mean, don't get me wrong. It's an extremely sad state of affairs, but it's not a safe port issue. I mean, ports may see it as such, but it's more of a local political issue than a safe port issue.
Okay. I've got a number of questions in the chat box, which is making a little bit difficult, not in the Q&A.
Jimmy, there is somebody talking about Chilean port, where the ropes part.
Yeah. Can you please, go ahead. You can read
I
the
thought
question.
that is one question that could be answered very easily, because we frequently party, because is definitely not something qualifies for an unsafe port. For the simple reason is that the simple master's navigation, if he brings in the proper seamanship, he puts the hawsers in such a way that there are sleeves around that, and he greases them and he takes care of them, and the ropes are tended in a particular manner and a particular time, then it can do it. Just for records, ours have been calling Chilean port for quite some time, and yes, the ropes part, but it doesn't make this port unsafe.
Right.
Also, of course, if it's a known incident that occurs regularly, then it's the abnormal occurrence element is right.
Gone. So, completely gone.
Yeah,
and then owners are also aware of that, so that again makes it different. I've got one more here. Catherine did mention the issue of the break of chain of causation in a safe port matter. Would she be able to explain this with reference to the Court of Appeal decision in the case of Kanchenjunga?
Interesting one for you, Catherine.
Yeah.
Quick answer, please.
Yeah, this is an essay, a law school essay exam question. Thank you very much for sending in that question. I kind of, when preparing for this seminar, was looking at the Kanchenjunga case really in the context of waiver and estoppel. So where the owner, as we've already discussed, is entitled to reject an unlawful order if the owner is right and it is an unlawful order, and request a lawful order to go to a safe port.
Yeah,
But
I
also
think it may be a good idea to send it to in writing if we can. Later on by email we can answer that question.
Yeah, but I suppose that sort of the take-home point on Kanchenjunga is really if owners agree with full knowledge of the potential danger or risk in the port, but comply with the order anyway and agree to go, they may have waived their rights to claim damages later. So the message is reserve your rights as an owner if you're going to agree to do that. And tribunals and courts are going to look very closely at correspondence between owners and charterers where owners have followed such an order with the knowledge of such a danger.
Okay, thank you. Now I think we got 3 minutes, and this would be the last question because it's equally tough, and I will have my lawyers to answer that. And in any case, we will send them the reply by email. It's by Mr. Baker Hang. In Ocean Victory, the implied indemnity claim failed as well. Do you have any thoughts in relation to this head of claim, in addition to the unsafe port claim? In what circumstances would an Ocean Victory matter implied indemnity claim succeed on the assumption that the employment orders were legitimate?
Oh.
It's not an easy one. It's
not one for now either, I would.
Yeah, so we leave this
with
one.
greatest of respect to Baker, I think that might be something we take out, we discuss separately.
We will
Predominantly because I need to read up on it if he needs an answer more than anything else.
All right. So I think with that, we just let me give my vote of thanks to all our co-organizers and sponsors. So I'd like to thank our co-organizers, Chartered Institute of Arbitrators, East Asia Branch, Hong Kong Maritime Arbitration Group, Singapore Chamber of Maritime Arbitration, SCMA, and of course, LMAA, London Maritime Arbitrators Association, and all our supporting organizations, which are almost 18 of them, and a number of media partners. They have been very kind, and some of them are live broadcasting the event. And as I said earlier, the panelists will reply to the questions raised during registration. I think there was one from Mr. Kirkis, and we will send the reply to you, and today's chat box as well as the Q&A. So ICS Hong Kong and WISTA Hong Kong will come back to you on the 12th of August to discuss the validity of NOR and lay time commencement. It's a big one, and we don't want that webinar to become a lecture. We are trying to pick out the key points, important ones, and to have a good discussion. This is an interesting topic, and I'm sure participants will have a number of takeaways. So I would like to end today's webinar with something that I read on one of the PNI Club Schools website. It says, in the words of Samuel Johnson, "He is no wise man who will quit a certainty for an uncertainty." The issue of ports berths safety, port berth safety warranty, is far too important to be left to be decided by the coin toss of a trial, and terms should thus be expressly agreed upon. So let's play it safe. Let's not leave the important clauses as our midnight clauses, and bring as much clarity. And as they mentioned earlier, it's absolutely essential. The club The PNI Club is there to support you, to give that complete input. So let's make full use of their knowledge and expertise and minimize the damages. And with that, once again to my panelists, Dimitris, thank you so much. Catherine, Captain Titarbe, Benjamin, it was so refreshing to hear what, just incidentally, I'm a member of the Diversity List 2017 of the Jubin Foundation, and I know an amazing work government is doing, foundation is doing on the ethnic minorities. Thank you so much. And Manson, thank you so much for your support. And Jeffrey, I have got it right. I will call you Mr. Bloom from tomorrow, not Mr. Blum. So, all right, with that, good night and wish you all the best. Have a lovely evening. Bye-bye.
Good night, everyone. Thank you.
Recording
Thanks for watching. See you next time. Bye for now.